be that difficult because I've kind of been talking about it throughout the semester because it's come up in other cases. So hopefully you will find this section very easy. So for a court to hear a particular claim, the court has to have jurisdiction over not only the person, which is personal jurisdiction, but also over the subject matter, right, of the lawsuit. We call this subject matter jurisdiction. As you know, there's basically two parallel court systems. There's a federal court system and a state court system. This class focuses primarily on the federal court system, but I just want to remind you of that. So when you're dealing with subject matter jurisdiction, you're basically asking yourself the question of what is the proper court, or which court can I file a case? Can it be filed in federal court? Can it be filed in state court? Can it be filed in both courts? And sometimes a case will only be able to be filed in state court. Sometimes it can only be filed in federal court. Sometimes you have the option of both. And strategically, if you have the option of both, depending on what type of case it is, what the context is of that particular local community, you're going to make a judgment call based on if you can file in both courts, which court will give your client the best advantage for a positive outcome. So during the first week of class, we talked about Article 3 of the Constitution. Article 3, Section 1 provides that, and again, I'm not going to test you on this, I'm just reminding you of where this all comes from. The judicial power is vested in the Supreme Court and inferior courts established by Congress. So Section 2 of Article 3 basically says that judicial power is expressly, meaning what power judges have, limited to only certain types of cases, right? So again, Section 2, Article 3 of the Constitution says that judicial power is expressly limited to certain types of cases. There are essentially 11 categories of cases that the judiciary is allowed to hear. We're just going to focus on the two most litigated and prevalent cases, which the first one is called arising under jurisdiction or federal question jurisdiction. The book uses those terms synonymously, so I want to make sure you know they mean the same thing. So there's two types of jurisdiction we're going to focus on for this class. The first one is arising under jurisdiction, which is the same thing as federal question jurisdiction. And the second one is diversity jurisdiction. So those two categories combined are called subject matter jurisdiction. So when I use the term subject matter jurisdiction, I'm either referring to federal question jurisdiction or diversity jurisdiction. But collectively they mean diversity jurisdiction. So those are two different ways you can establish subject matter jurisdiction. Either you can get it in federal court based on diversity jurisdiction, or you can file the case in federal court based on federal question jurisdiction, again, which means the same thing as arising under jurisdiction. Any questions about those two things? All right. So the Constitution does prohibit many cases from being filed in federal court. And I'll talk about some of those limitations in a minute. But I first want to just briefly focus on statutory authorization and how that applies to this area of law. So essentially it's not enough that the Constitution authorizes an exercise of jurisdiction. There also has to be some type of statute by which authorizes the courts to hear particular matters. So again, it's not enough that the Constitution says yes. You know, there are 11 categories of cases that the judiciary can hear. Again, in our class, we're focusing on the two most litigated cases, which are diversity jurisdiction types of subject matter jurisdiction and federal question types of subject matter jurisdiction. But in addition to that constitutional authorization, there has to be a statutory authorization as well. So Congress has created two statutes to authorize subject matter jurisdiction. So the first one is 1331. So when I said there's two types of subject matter jurisdiction, the first one is federal question jurisdiction, and the statute that authorizes that is section 1331. And for diversity jurisdiction, Congress created a statute that authorizes that, which is 1332. So 1331 is federal question jurisdiction, 1332 is diversity jurisdiction. So in that book I told you that is every attorney's guide to filing a case in civil courts, called the Federal Rules of Civil Procedure Statutory Supplement. I didn't have you get that book because it was just more money, but the rules are online. So all that is to say is if you were to Google Civil Procedure Rule Section 1331, you would see federal question jurisdiction, and it describes what that includes. I'll explain in a little bit. Same thing with 1332. If you were to Google that, it's going to tell you the diversity jurisdiction and what the requirements are for that. And again, I will go over that. So before I discuss federal question subject matter jurisdiction, I want to quickly talk about the concept of state court. So we've got federal court subject matter jurisdiction and then state court subject matter jurisdiction. Remember, we have these two court systems. So the requirement of subject matter jurisdiction also applies to state court systems as well. States determine jurisdiction of their courts by their own legislative state codes. So they have their own version of section 1331 and 1332. They're different numbers, obviously, depending on what state. But I just want you to know if you're trying to file a case in state court, you're going to look up what their state subject matter codes are, or laws that tell you what the criteria is to file a case in state court. Typically, the way that these state codes or statutes are set up for state subject matter jurisdiction, meaning in state courts, is that they'll say this type of case has to be heard in this type of state court. So typically they'll say if it's a family matter, it has to be held, you have to try the case in a family court. Or if it's a juvenile matter, as you know, they have juvenile court. So the state courts have statutes that basically tell you, that bankruptcy court is another example. So depending on what your subject matter is, they'll tell you which is the appropriate court to file in, again, if you want to file in a state court versus a federal court. Another example, small, if they'll say, like, if your amount in controversies under, $20,000, it's going to be filed in small claims court, would be another example. So each state has their criteria that tells you which court within their state court system to file your case in. So that would mean that the state court is not only going to have personal jurisdiction over that non-resident defendant, you're going to have to make sure that you choose the right court to file the case in based on what the subject matter is of your lawsuit. Any questions about that? Okay. So let's go back to federal question jurisdiction. Smile, Jessica. All right, so the most important types of subject matter jurisdiction in federal court that this class will cover, again, are those two categories I mentioned, federal question jurisdiction and subject matter jurisdiction. I first want to talk about federal question jurisdiction, again, which is section 1331 of the United States Code. And so Article 3 of the Constitution extends the permissible scope of federal judicial power to cases that arise under federal law, meaning they have to do in some way with federal law, such as federal treaties. If any type of treaty is automatically, federal courts will have subject matter jurisdiction over it. If it's a federal statute, such as the FMLA, Family Medical Leave Act, or the ERISA Act, or retirement, or Title VII, Title IX, those would be federal statutes. So federal courts would automatically have subject matter jurisdiction over those cases, meaning you can file those cases in federal court because they involve a federal question, meaning dealing with a treaty, a federal statute, or if it's dealing with the federal constitution, not a state constitution issue. So if it's a First Amendment issue, a Fourth Amendment search and seizure issue, if it's something dealing with the Equal Protection Clause, those are all federal questions, meaning they deal with the Constitution. So federal courts have subject matter jurisdiction over those types of cases. So again, federal question jurisdiction applies to cases that deal with federal treaties, federal statutes, or federal questions of law regarding the Constitution. Those three areas. Okay, so in terms of exclusivity and federal question subject matter jurisdiction, in many cases, federal question subject matter jurisdiction is not exclusive to federal courts, right? So I mentioned earlier, state courts can hear federal question cases. So just because the case deals with the First Amendment doesn't mean it has to be heard in federal court. It means you have the option of choosing, do I want to file this case, this First Amendment freedom of speech challenge in federal court, or do I want to file it in state court? But there are some cases that subject matters that can only exclusively be heard in a federal court, meaning you don't have the option of choosing. They're very rare, but some examples are antitrust cases have to be heard in federal court. Patent law cases have to be heard in federal court. Copyright cases have to be held in federal court. So in your statutory supplement, it lists which subject areas. Admiralty law have to be held. Those cases have to be heard in federal court. But unless it's one of those exclusivity exceptions, you have the choice of having your case heard in federal court versus state court. So some of the policy reasons for extending federal power to federal question cases is there's a couple of reasons. So Congress felt like it was a good idea to allow federal courts to hear cases dealing with, again, treaties, the Constitution, or statutes for a couple of reasons. The first is they wanted to promote uniformity in federal law, which makes sense. When you think the smaller number of federal judges as compared to state courts, so there are like 3 times as many state court judges as federal judges. So they were hoping that this would promote uniformity in how federal law is being interpreted by having them heard in these federal courts. Another policy reason for extending federal power to hear in these types of cases is expertise with federal law. They thought it would be good to have a federal court system where the judges' areas of expertise are going to be the federal Constitution, it's going to be treaties, it's going to be these federal statutes, right? They think that federal judges are more familiar, which makes sense, with federal laws, issues, and policies. The third policy reason is to avoid state court hostility. Now, what do I mean by avoid state court hostility? Basically, Congress said we don't trust the states, right? We want to avoid a situation where states are doing things that are beneficial to themselves, even if it goes against the national trend. Additionally, they said that federal judges are less susceptible to pressure because they have life tenure, meaning once they're voted in, plus they have salary protection. So they felt that federal judges are better able to protect unpopular rights because they're less likely to be susceptible to the pressures of, oh, I need to be reelected. If I rule this way, it might affect my run to get reelected again. So essentially Congress felt like, some of these rights such as, again, freedom of speech, freedom of association, Fourth Amendment rights, equal protection rights were so important that they wanted to create a federal power and invested in federal court judges to kind of he's a gatekeeper essentially of protecting those rights. And because, again, of the fact that they have lifetime appointments, their salaries are protected, they're less likely to be susceptible to outside pressure. So that was the idea behind that. So again, two types of subject matter jurisdiction. You only need to satisfy one. You're going to have federal question or arising under jurisdiction, or you're going to have diversity jurisdiction. With respect to diversity jurisdiction, the requirements are two things. One, the plaintiff and defendant have to be citizens of different states or domiciled in different states. For subject matter jurisdiction, the plaintiff and defendant have to be citizens of different states. So you have to have diversity of citizenship is what they call it. So I, the plaintiff, am a resident of Kentucky. The defendant has to be a resident of Ohio or Texas or Kansas or whatever. The second requirement, and then I'll get your question, for diversity jurisdiction, is that the amount in controversy has to exceed $75,000. The amount you're asking for, redress, whatever. Because remember, it's civil court, not criminal court. So it can be $75,000 in one sit, and that qualifies, but it has to exceed $75,000. Jessica?
What if one of the parties technically lives in two different states?
Yeah, so if she said if a party technically lives in two different states. So for domicile, and I'm glad she brought that up, in determining this, a person can only have one domicile, right? A corporation can have two domiciles, meaning places where they are considered residents. So a corporation's domicile is either going to be their place of incorporation or their principal place of business. So we've seen companies where they're incorporated in Delaware, but their principal place of business is in St. Louis. So either of those states would work. But a person can only have one domicile. So as the plaintiff's attorney, it's your job to make the argument that the defendant is domiciled in one of those two states that Jessica mentioned. And so what they look for, as we saw in our practice assessment today, is where they intend to remain indefinitely. That's really the key. So, yes, I might live in Kentucky and Illinois, but it's your job to establish, based on where you want to file the lawsuit, where I intend to remain indefinitely. You could make the argument, I intend to remain here in Kentucky indefinitely because I've accepted a job here, I've built my career here, I have a home here, and whatever. But then you could say, no, it's more advantageous for us to file the case in Illinois, so we're going to argue that Professor McNeil, although she lives in Kentucky, she also has a home in Illinois. She's had that home for years. In addition, her bar license is in the state of Illinois, and her kids are in school in Illinois, so that's really where she plans on remaining indefinitely. Sometimes it's not cut and dry as the situation I just said, but the judge is just going to have to make a judgment call of people that are commuting or doing the bi-coastal lifestyle, where do they intend to remain indefinitely. So it's not always cut and dry, but you make the best argument and the judge makes the final decision. They look at where they file their taxes. That's always helpful. That's another thing they look at. Are they an out-of-state student? Are they paying in-state residents? Those types of things. That's what keeps us employed, making those arguments. Okay, any questions about those two types? That's subject matter jurisdiction in a nutshell. All right, let's go ahead and do the Louisville, Nashville Railroad case. And I will ask for assistance. Attorney Allen, have I already called on you? So I lost my sheet. Where art thou? Emily?
She's not here.
Lucky lady. What about Leanna?
I knew it. Yes.
How do you know?
We just knew. Yeah, I can go.
Yeah, but how did you know?
You didn't have a choice.
All right, Leanna, we need your co-counsel, so,
Can I pick one?
Calm down.
are there more girls, females in here than men?
Yes.
Yes.
Yeah, that's why I'm struggling. What about Madison? Where art thou?
I go by
Bailey.
Bailey, and I also unfortunately did not read because I read your email wrong. So I thought that we were only going over the personal jurisdiction question today.
And you go by Bailey?
Yes. I did write that on the original sheet.
All
But I
right.
can also be prepared for tomorrow.
I always follow my gut. I believe you, so I'm not upset with you. What about Attorney Klatt? Are you
I
volunteering?
was about to volunteer, yeah.
Are you gonna volunteer to be Tribune?
Yeah, that's fine.
What's your last name?
Peyton Clapp.
Oh, and I was actually calling.
Yeah.
Isn't that weird?
Yeah.
Oh my God, I'm gonna play the lottery. That's freaky weird. All right. Can I tell you all I'm a germaphobe and I just want to lie in the middle of the floor right there and go to sleep? That was you. Major germaphobe. Okay.
This roach has been on it.
That's, please, Attorney Klatt.
So Erasmus and Annie Motley were injured in a railway accident, and they were given lifetime free passes, for the railroad in 1971. Decades later, there's a bill passed prohibiting lifetime passes because of a fear of bribing public officials with the passes. And so the railroad company no longer honored the Motley's lifetime free passes. So the Motley's filed a suit with the court.
Okay, sorry, I sabotaged you. Say the last part, they filed their case where?
In a circuit court claiming that it's a federal question case.
Alrighty. Let me just pull something up really quick that I just remembered. I hate that I don't know these keyboards here. Oh, come on. Can I do it? Alright, so we have the Motleys giving this free train pass by the defendants in a personal injury settlement, 1871. Thank you, Attorney Klatt. Congress, however, passed a law, right, in 1906 that outlaws these free passes. Well, I'm going to be pretty upset if I've gotten a free railroad pass and then they pass a law that says that my pass is no longer valid. And the reason Congress passed the law is to prevent the railroad company essentially from bribing officials, at least according to the railroad company. So Louisville and Nashville railroads stopped letting people basically get on with the free pass. The Motleys are ticked off. I don't blame them. They sue in federal court seeking specific performance of the contract. And so Attorney Banda Cruz, what is the federal trial court holding in this case?
Hold on. Is that where they denied the Motley's complaint? Or am I looking in the wrong area?
Trial court. Oh, Elizabeth. What's interesting is that you have briefed the case, but you don't know where it is in the case.
She's just nervous.
Are you nervous?
She is.
How could you be nervous with me?
I have no idea. I asked my that same question many times.
I can't believe
She
you
will
know people.
freak out and be like, oh my God, what if I'm on call?
Does everyone stop and just look at her? So we'll try again. Trial court says.
Okay, so the federal trial court overruled the DeMoran and granted the Motleys the relief they had requested, and the defendant railroad appealed to the Supreme Court.
Perfect. All right. So we know the trial court says yes, there is subject matter jurisdiction, and they held for the plaintiff, the Motleys, and the appellate court affirms that as well. So the plaintiffs, in this case, I think, have some pretty good points, right? We said we wanted federal courts to decide constitutional questions and probably interpret federal law as well. That was the goal. The Motleys bring this suit to have the federal courts do just that, right? So why isn't there federal question subject matter jurisdiction, Attorney Klatt?
So the court basically says that it wasn't a federal question, it was more of a breach of contract.
Can you elaborate on that, Attorney Cruz?
I'm sorry, can you repeat the question?
Yeah, so why isn't there a federal question subject matter jurisdiction here? He said because the federal courts essentially said it was a state court contract issue. Can you give me a little bit more depth on that?
Because the cause of action is under state law, not federal law.
Okay, and what else did they say in their analysis, reasoning?
They technically that the railroad just violated the contract that fell under state law.
Okay, Attorney Klatt, what did they say about the well pleaded complaint rule in this case? I think your co-counsel has jumped in. Go ahead.
That the state, it must state the defendant directly violated some provision of the Constitution, laws, or treaties of the United States.
Okay, and what were you gonna say, Attorney Klatt?
I'm not sure. I mean, the thing that I got was that it has to be a federal question first and foremost.
Yes, that's what I
rather
want.
than-
Say it
okay,
again.
Rather than, basically, the first issue is if it's a breach of contract, and then the second issue is does the breach of contract violate their federal question, or violate their Fifth Amendment due process rights? So
Thank
that's
you.
the federal question.
Awesome. All right, so the court says that these are just anticipated defenses, right? And that the plaintiff's claim, as Attorney Klatt said, really is just a state breach of contract claim, right? Defendant will, of course, defend based on this federal statute, but the initial claim is not a federal question claim, is the whole point. So the court says it's not enough for the defendant to use a federal statute to respond to the claim. The initial claim has to be based on a federal treaty, a federal question, or a federal statute. So this is known as the well-pleaded complaint rule. The court says that in order for a federal court to exercise federal question subject matter jurisdiction, a suit arises under the Constitution of the laws only when the plaintiff's statement of his own cause of action shows it's based on a law of the Constitution. So the plaintiff's initial cause of action has to be based not on the state contract issue, but on a federal question. And that was the problem here. The initial claim that the plaintiff filed was not based on a federal question. It's not enough that the plaintiff alleges, again, some anticipated defense to the cause of action and asserts that the defense is invalidated by the Constitution. So what's the plaintiff's argument for why subject matter jurisdiction exists in federal court? They give two reasons. Either, attorney, what's the plaintiff's argument why subject matter jurisdiction does exist in federal court? They basically say that the plaintiff's complaint raises two federal questions. What are those federal questions they say that are raised in the complaint? Again, what are the plaintiff's arguments for why subject matter jurisdiction exists?
So that act of Congress doesn't prohibit giving the free passes.
Okay.
And that if the law is to be construed as prohibiting such passes, it's in conflict with the Fifth Amendment of the Constitution because it deprives the plaintiffs of their property.
Perfect. Yeah, so the plaintiff complaint raises two federal questions. First, claims that the 1906 law doesn't really outlaw those kinds of passes. This is a question about an interpretation of federal laws, what the plaintiff says. And then second, if the 1906 law does outlaw these types of passes, it's unconstitutional because it violates the Fifth Amendment and deprives them of their property without due process of law. So what the court is saying is that the federal claim, again, must appear as part of the well-pleaded complaint by the plaintiff. So in the Motley's claim, the central issue was federal defense rather than part of the plaintiff's claim. The Motley's claim, again, as I've stated already, arises out of a state breach of contract issue. Its reply to the defendant's federal defense is not enough to satisfy subject matter jurisdiction. So this is a pretty clear-cut case. All it means is that, again, the plaintiff's initial claim must arise out of a federal question, right? It can't be a defense. You can't, that's the easiest way. The initial claim has to arise out of a federal question. So recapping the Motley, case, and the black letter law that comes out of here is called the well-pleaded complaint rule. In order to revoke jurisdiction under section 1331, federal law must be part of the plaintiff's well-pleaded complaint, meaning the initial complaint must be based on federal law to satisfy 1331. There are two important points to this rule. First, the court looks only to the plaintiff's complaint. Again, it's irrelevant what the defendant's defenses are. Second, in looking at the plaintiff's complaint, the court addresses only, again, the well-pleaded parts of the complaint. So they're only looking at that initial cause of action. Is it based on a federal question? If not, it doesn't satisfy 1331. And so when they keep using the term well-pleaded, what does that mean? So well-pleaded just refers to the part of the plaintiff's claim supporting only the plaintiff's claim. So when they say they only look at the well-pleaded part of the complaint, it's the part of the plaintiff's complaint supporting only the plaintiff's claim. So in other words, the court ignores any extra material the plaintiff may have put in the complaint, stuff that doesn't relate to their claim. An example would be if the plaintiff's complaint anticipates that the defendant might raise a particular defense and attempts to rebut it in advance, they're probably going to say they weren't negligent, and they don't care about any of that. So all they're looking at is the plaintiff's initial complaint, whatever that claim is it a federal question? If not, 1331 is not satisfied. And that's pretty much it. Yes, ma'am.
So then to answer the question, the state court would have to interpret federal law?
Okay, I heard the last part, the state court would have to answer federal law. What was the first part?
So like to answer to the court to decide this case, would they have to interpret federal law?
If a state court
So
decides?
yeah.
Yes.
Okay.
Good question. Yes.
I'm still a little confused because the way I'm reading the case, it still sounds like a federal question was part of the initial claim, because before the Motley brought the suit, the railroad denied them the use of the passes, they're citing that federal legislation. And so it seemed to me like the question was, is that actually like the reason why this is happening? Is that actually like a claim they can use to get out of the contract?
Right, but the whole thing is, the basis of it is by them using that law is a breach of contract claim. They breached their contract, meaning the passes, they're not honoring the passes. So the breach of the contract claim, the reason they're not honoring the passes, that's a defense. No, we're not honoring it because of this law, but the initial claim is a breach of contract claim. That's why. The defense is, no, we're not in breach of contract, we're trying to follow this federal law. But it's not the basis of the actual claim. Any more questions? All right. Cool. I hate the clock isn't working, but now I can see it's 9:38. Awesome. So the assessment. So tell me what you think. So I would like to look at your questions. I scanned through them, but I did not write notes on them because I was not feeling well. Do you need these back? Do you have a hard copy of them? The people that turned in the hard copies. Does anyone not have a copy of their response? Okay, just you. 2 people, 3. Okay, so if you don't have a copy, tell me your last name and I'll.
Do you mean
pull it
like
up.
right here, right now, or do you just
Yeah,
mean
with
permanent?
you.
I have it on my laptop.
Okay, so just raise your hand if you physically don't have your response with you. Okay, 2 people. Last names, I forget, I'm sorry.
Cole, C-U-L-L.
Say it again.
C-U-L-L, Cole.
Okay, and your last name?
Clements.
Okay.
And Douglas.
Oh, never mind, I don't need it.
I'm dying. was trying to like slide it and you wasn't like looking. I was like,
Clement's scared, sorry, got that quick. Okay, that works. Okay. And here. Anyone need the question again? You?
what was your shirt, Big Bird? Your parents up. We see. I didn't even talk about notice. I didn't do it either. Right. I tried to do Marcus some thing too. This is an outline.
Okay, so. I'm good, I have a paper. Okay. So before we look at this, I want to show you something really quickly. Even though I should have waited to give it to you tonight, I'm not gonna look. But there's a guy, American Airlines passes. lifetime. Awesome. You remind me of the Motley case, but so yeah. So American Airlines had this thing, and I'm so sad I didn't get to do it, but it's you pay $250,000 and you could fly unlimited for a lifetime. And it says they didn't account for super travelers like Jacques Vroom and Steve Rothstein. And so, again, these are their words, not mine. 3 decades ago, 20 lucky bastards managed to snag the greatest travel deal in history, courtesy of American Airlines. It was an unlimited air pass. So you pay, again, that $250,000, and you have unlimited first-class travel for life. And so Mark Cuban, an early American Pass or whatever, he says it's one of the best purchases he ever made. Listen how this guy did this stuff. It's incredible. Where is it at? You got to hear the trips he did. It was incredible. Where is it? He took hundreds of trips to New York, LA, and San Francisco. He went to London sometimes a dozen times per month. He flew up to Ontario just for a sandwich. On occasion, he'd offer his companion pass to a complete stranger at the airport. Like, you got a companion pass with that. The contract was truly unlimited, he says, so why not use it as intended? He booked more than 10,000 flights. In 1987, Steve Rothstein brought the pass, giving him unlimited whatever. Look where he did 1,000 flights to New York City, 500 flights to San Francisco, 500 flights to Los Angeles. Like, look at that, 120 flights to Tokyo, 80 flights to Paris. He would just go just to have dinner and turn around and come back. Because he's in first class, he's sleeping in those comfortable thingies the whole time. And so, over in Texas, it says direct marketing catalog consultant by the name of Jacques Vroom decided to shell out, money as well. And so, basically, American got upset and they tried to take their pass away because they said that they were, exploiting it. And the guy says, no, they, he sued them. He said the pass says unlimited, it doesn't have restrictions. Because it was costing the airline $1 million, I'm sleepy, $1 million a year, for each one of these passengers. So they said he made 3,000 reservations in the span of 4 years. Again, booking flights for strangers and allegedly accepted payment for tickets. Sometimes he's like, you want to ride? What do you see?
No, that seems like that could be.
I think it's, it's a breach. So Rothstein and Vroom both filed lawsuits against American Airlines for wrongful termination of their contracts, but were outmatched by the airline's bazillion lawyers. In 2011, American filed for Chapter 11 bankruptcy, catapulting them into an indefinite legal limbo. So anyway, I just thought it was interesting because our right to inform you effective immediately. American Airlines hereby exercising its right to terminate your AA Air Pass agreement. So I didn't look at the appeals process, but isn't that amazing? 250,000 unlimited. Like, I would get a loan to do that. Like, I would take out a mortgage on my home because first class, you can literally see the world. Like, that's, and a companion. I just thought it was incredible. Anyway.
I don't have the time.
All summer students, you would just fly for it. I would do it. Go away. Okay. So this is just a student's response from a couple of years ago, maybe 2 years. It's not the perfect response, but it's good enough. They did a great job. So let's go ahead and just kind of go through it. Just as a reminder, I'm going to try to read through it relatively quickly. You're a lawyer working for a firm in the state of Georgia. One of the firm's partners asked you to do some research on a personal injury action. Pam Pedestrian is a Georgia resident who's injured in an accident in the state of North Carolina while on summer vacation there. A truck driven by the employee of B Corporation collided with a car driven by David Driver, causing driver's car to swerve onto the sidewalk and strike the pedestrian. The partner wants to sue both the B Corporation and David Driver in Georgia or North Carolina. I know that you consider Florida, but the attorney just wants to pick one of those two states. The partner hands you a file in the pedestrian's case with the following information. Pedestrian is a doctor who practices in Georgia. She owns a home in Georgia where she was born and reared and plans to live out her days. Anytime you see plans to live out her days, you're going to jump on that as an attorney, because you're going to say that's where they intend to remain indefinitely. She was injured in the accident, and if liability can be established, she could hope to recover $250,000. So just as a teachable moment, her recovery is asking for $250,000. Even though we don't discuss subject matter jurisdiction in this case, what you would look at is, maybe we can file this case in federal court under subject matter diversity jurisdiction because the amount in controversy is more than $75,000 and the plaintiff and defendant are citizens of different states. So that's how subject matter jurisdiction would work. Yes, ma'am.
Just a quick question. So
Please.
they say driver was from Georgia as well, and then what if you have two defendants and one is from the same state, but then the other one is not?
Okay, so you said what if two defendants and one is from the same state?
As the plaintiff.
As a plaintiff.
Is it still
Yeah, so we haven't covered that yet, but it's a great question. So if you didn't hear her, she said what if you have plaintiff is from Kentucky, defendant 1 is from New York, but defendant 2 is from Kentucky as well. And so there's a complete diversity rule. We're covering the same class. Essentially, that cancels out diversity jurisdiction, but we'll talk about it. We have a case on the complete diversity rule. There's a couple of rules that go with that. So good question. Okay, so David the driver is a third-year law student who lived at his parents' home in Georgia through high school. He moved to on-campus housing at Georgia State as an undergraduate and then obtained an off-campus apartment in Florida where he became an out-of-state Florida State University law student. That out-of-state, again, looking for buzzwords. Driver's parents support him, another buzzword, while he attends law school. He frequently returns to his parents' home in Georgia during school vacation periods. Between driver's second and third year of law school, he is a summer associate at a Florida law firm. At the beginning of his third year of law school, driver moved from the smaller off-campus apartment he occupied during his first 2 years of law school into the more spacious apartment he is now leasing for 1 year. 2 months ago, driver received an offer for a full-time job with a law firm in North Carolina after graduation. He obtained the offer at an interview conducted at FSU, but he never visited the firm or North Carolina. He shared with his friends that he only intends to remain in Florida until graduation, which is 5 months away. Just recently, driver inherited a house in North Carolina. Oh no, we've got property from a cousin. He has never seen or occupied the house, which is currently being rented to tenants pursuant to a lease that expires in 6 months. Driver has filled out the paperwork to take the North Carolina bar exam. The deadline for applying to the Georgia bar is several months away, so he still can apply to the Georgia bar. We have B corporations. Since they're a corporation, it means what? They can be domiciled, have 2 domiciles where they're incorporated and their principal place of business. So B corporation, the floor is a shoe manufacturer incorporated in the state of Florida, so we know that's one of their domiciles. Its home office and manufacturing plants are located in the state of North Carolina. That's their principal place of business. That's their second domicile. Consequently, its corporate officers and all of its employees are located in North Carolina. Although a few of its sales representatives occasionally travel in neighboring states and take shoe orders. B Corporation sells most of its shoes in North Carolina, but sells a substantial number of shoes to wholesalers in both Florida and Georgia. The truck involved in the accident was passing through North Carolina while transporting a shoe display to an industrial fair in another state. The long-arm statute in Florida allows courts to exercise jurisdiction on any basis not inconsistent with the U.S. Constitution, and then we have the long-arm statute on the back. So we know that North Carolina has that broad California-style long-arm statute. North Carolina does not. So, we have a sample student response here. Plaintiff would prefer to bring her lawsuit in Georgia where it's most convenient. She'd also like to sue both defendants in a single action, less expensive. The call to question only requires that I address Georgia and North Carolina as potential forums. Plaintiff is probably domiciled in Georgia because the facts inform that she's a Georgia resident who plans to live in Georgia indefinitely. Therefore, she's both physically present in Georgia and intends to remain there indefinitely. Although notice is not mentioned in the fact pattern, it is important to note that notice must be proper to file a case in civil court, whether it's in Georgia or North Carolina. Proper notice requires both a statutory and constitutional analysis. The statutory analysis examines whether the notice provided complies with Rule 4. The constitutional analysis evaluates whether notice was given was reasonably calculated. Remember, we talked about the Mullane rule, is the notice reasonably calculated to inform the defendant that a lawsuit has been filed against them. That was not in the call to question. The student was just kind of showing off what they know. Whatever. Kudos. All right, so let's first look at Georgia as a forum state. So we're first going to do that statutory analysis, right? We're going to see if the long-arm statute applies before we even discuss general or specific jurisdiction. So the Georgia long-arm statute, because it's a California style, we know we check the box. We move on to our statutory analysis. Constitutional analysis, sorry. Just as a general rule, you don't have to, but typically attorneys will first try to establish general jurisdiction, and then they'll try to establish specific jurisdiction. The reason they try to establish general jurisdiction first is because if you have general jurisdiction over a non-resident defendant, you can bring multiple different claims against them. Negligence, contracts, whatever. If it's specific jurisdiction, you can only bring claims that arise out of the defendant's activities in that state specifically, okay? So, in terms of general jurisdiction, we're just looking to see if there are substantial contacts enough to where the individual feels they're at home in that state, which here is Georgia. Looking at the facts, the student has driver remains dependent upon their parents, Georgia residents, who are supporting them financially while he completes his legal education. During vacations, he returns to their home in Georgia where he lived during high school and undergraduate years. Again, the facts characterized Driver as an out-of-state Florida student who only recently inherited the house in North Carolina. It is likely that he retained his citizenship in Georgia when he moved to Florida initially. Though he has a job offer from a North Carolina firm and a house in North Carolina, has applied to take the North Carolina bar exam, he's made no firm commitment to move there and live indefinitely. He's not accepted a job offer there and is not foreclosed from working or taking the bar in other jurisdictions, including Georgia. He could return to Georgia after graduation where he has lived previously, even though the facts don't speak to the post-graduation job prospect. So what's important about this is that, and even outside of my classes, when you write your exams, we want you to feel like you're having a discussion with us. If you are showing us you considered all the options, you considered, oh, well, this is why he's not probably domiciled in Florida. This is why he's, more likely domiciled in Georgia. But that's what, on your exams from last semester, when they say, oh, there's not enough analysis, they want to see what you're thinking in your head on the papers. They want to see how you come to your conclusion. Even if it's the right answer, you're going to get more credit for showing that you evaluated, you did the steps of analysis in making your decision. And that's what is being done here. So even if you were to make the argument that you think it's North Carolina because he has property there and those things, that's for a judge to decide. So this isn't like this is the answer. I can have an opinion that this is a stronger response, or better supported, meaning a stronger evidentiary basis. But I just, as a side note, law faculty, what we're looking for is for you all to show us that you know how to think like an attorney, you know how to apply the law. We don't necessarily have to agree with your outcome. There are some exceptions where there really is just one answer. But in a lot of cases, there might be an argument stronger than another, but again, we're supposed to evaluate you on how well you apply the law, know the law, and if you make a logical conclusion. So here we have the student is saying Driver could be considered to be domiciled in Georgia, such that Georgia could exercise general jurisdiction. He does have a lot of contacts. There's definitely enough to satisfy that substantial contacts. Does anybody make the argument that there wasn't general jurisdiction in Georgia for Driver? Okay. Oh, you?
Can you say, he's not living on campus any longer, he's moved into an apartment, he's accepted a job in North Carolina, he's told all his friends he doesn't want to live in Florida. He's kind of severed ties from Georgia in a way. I don't know, it's not a strong argument, but there's an argument, right?
Yes.
Okay.
Yes.
I did it, but through long-arm statutes, but I had a question of it, since it was, what about the, the non-resident motorist statutes, do those not apply because it wasn't it's looking at the pedestrian injuries?
Yes and yes.
Okay.
Yes and no. So she's referring to, remember we talked about how each state has the non-motorist statute. Basically, if you're involved in an accident, that state has jurisdiction over you with respect to litigating that accident. Because it is a pedestrian involved, we're looking at it from a different angle, but it depends on the state. Some states will include the pedestrian, others will say no, it has to be just two cars colliding, not hitting an individual. So it depends on the state. Any other questions before we move forward? Yes.
You mentioned that all those facts are enough to satisfy that he has substantial contacts with Georgia. Where do we emphasize substantial contacts, and where do we emphasize he's most likely domiciled there? Or are they
Yeah, they kind of go together. So she's asking a question about distinguishing between where they're domiciled and if they have substantial contacts. So essentially what happens is you have a set of facts, and you use the facts based on what element of the complaint that you're trying to prove. So we haven't looked at a complaint yet because I'm trying to teach you the separate parts, and then I'll let you see how it all looks together. But when you file the complaint in civil court, you're going to have a section that says, there's personal jurisdiction. The court has personal jurisdiction over this defendant because of blah. The court has subject matter jurisdiction over the defendant because of X, Y, and Z. And so if you're trying to make an argument for subject matter jurisdiction, you're going to use those same facts and say they're domiciled there. But if you're trying to make an argument that the court has personal jurisdiction over the non-resident defendant under general jurisdiction, you're gonna use those same facts to say, you know, they have all these contacts with the state. So the facts are there to use for these different parts of the complaint. Does that make sense? Yeah, so you're basically gonna have the client come into your office and they're going to give you a set of facts and you're just trying to figure out if you can satisfy those 5 things in the complaint to file the case. And you use the facts for those different sections, same set of facts. All right, specific jurisdiction. Because it's possible that the driver could be determined not to have substantial contacts in Georgia, since he may not be considered domiciled in Georgia, it's necessary to do a specific jurisdiction analysis. So they do minimum contacts. Driver's contacts with Georgia, pretty obvious, lived there, attended school there, blah, 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 parents. Should be enough to satisfy the systematic and continuous thing. Driver's contacts with Georgia are not isolated or random. What they should have included in that section, they did, where the driver purposely availed themselves excuse me, to the state of Georgia. So that's something that the student did miss in there, if you want to include it in your notes. They did include the due process fairness considerations, those factors from the Volkswagen case, and said the state has significant interest in the case because the plaintiff is a Georgia domiciled in Georgia, basically, but that the interest is diminished by the fact that the accident occurred in North Carolina. Though driver might argue the plaintiff has an alternative forum, which is North Carolina. Georgia is convenient, obviously, for a driver. Remember, under specific jurisdiction, the cause of action has to arise from the non-resident defendant's activities in the state. And essentially, students said that criteria would be challenging to satisfy because the driver's contacts with Georgia, again, which are attending school there, living there, visiting there, are not related to the cause of action giving rise to the lawsuit, which is true. The North Carolina car accident has nothing to do, not with him living or going to school in the state of Georgia. Excuse me. The plaintiff is not likely to be able to establish specific jurisdiction again because that cause of action element is not met. Negligence claim not related to driver's contacts. Can you see, oh, yes.
Yeah, I just had a question on, like, when you're analyzing that part, if you believe that part, like it's not related to their activities, would you still have to go through like the analysis as far as like the fairness and everything?
Yeah, so that's a great question, and that's on exams, that's what gets the A's from the B's. What the professors will say is, you know, the students showed they knew how to do the complete analysis from beginning to start, even though a lot of students will take your stance, which is the logical stance. Well, it's obvious there's not specific jurisdiction, I'm gonna move on, I've already established that. But we wanna see you do the whole workup, we wanna know that you know how to do the whole process.
But in like a real case, like
In real life,
would they want that
No.
establish that first before?
yeah, so in real life, which is what you're asking, right?
Yeah.
Yeah, so outside, in the real world, no, you would stop there, you wouldn't, there's no point in doing the other factors. But in the law school world, we wanna see your work, yes.
What about tag jurisdiction? Could you not say that if he was served when he was home visiting or something in the state of Georgia, that they could?
Yeah, absolutely, so tag jurisdiction is always an option if they're served with process while they're in the state's boundaries, absolutely. But for exam purposes, I would put in the fact pattern that he was served with process in the state, hoping that you would know that that establishes tag jurisdiction. But if it's not in there and you mention it, it's just a bonus, which is a good thing. All right, so B corporation. So looking at their domicile, again, they can have two because they're a corporation. We know that they're not domiciled in Georgia, not a state of corporation, and the headquarters are in North Carolina, so Georgia is not B corporation's principal place of business. In terms of trying to establish general jurisdiction based on substantial contacts, they have all the things listed there. B corporations probably not subject to general jurisdiction in Georgia because, again, their contacts are not substantial enough to establish that they are essentially at home in the state of Georgia. Any questions about the B corporation? Is it helpful to see kind of how it's all falling, blending together? That's the purpose. Because it's hard when, you know, we teach you parts and then you kind of don't see the big picture, like where does it all go? What does this look like? So these steps in this assessment are the same things you would write in a complaint. Like when I show you an actual complaint filed in civil court, you're gonna be like, oh, I get it. Yeah, I totally get it. I know how to do each section, so you'll feel really good, trust me. All right, specific jurisdiction then, since we know general's not looking good. We're gonna look at minimum contacts. Beef Corporation has done business with a Georgia wholesaler, supplying it with substantial inventory, therefore purposely injecting its products into the stream of commerce. If you were in an essay setting, I would want you to talk about Brennan versus O'Connor stance. Sorry, excuse me. Therefore, establishing a reasonable expectation that it could be sued in Georgia by virtue of the sale of its products within the state. These contacts should be sufficient to satisfy minimum contacts. I agree. Due process, again, just considering those Volkswagen factors, which you can look at on your own. And then always under specific jurisdiction, again, we always look at whether the cause of action arises from the non-resident defendant's contacts with the state. This criteria would be hard to satisfy here because providing shoes to the wholesaler, obviously you can make the argument it's not related to this North Carolina accident, which gave rise to the plaintiff's negligence claim. Plaintiff could contend, however, that both the Georgia activities and the accident that give rise to the claim are related to the sale of the shoes, and therefore the criterion is satisfied. But the stronger argument, of course, is that it's unrelated, but you get credit for both. So we know that B Corporation is probably not subject to general or specific jurisdiction. Plaintiff probably not able to sue both defendants in Georgia. North Carolina as a potential forum state. We've got Driver. North Carolina has a narrow long-arm statute, so we have to see if any of those prongs apply. Prong 2, which brings defendants within its reach because they own property within the state, the home that he inherited, because the recent inheritance of the house. The personal injury claim did not arise out of their ownership of that house. So prong 1 is probably better in terms of satisfying the North Carolina long-arm statute, which again, the car accident gave rise to the personal injury action. That satisfies that element of the statute. Did anyone have any problems applying that long-arm statute? It should be easy for you at this point. Cool. General jurisdiction, again, trying to see if they have substantial contact. You see that he does have a lot of contact with the state. The problem is, or the challenge is, again, with an individual, the court is looking at where they intend to remain indefinitely. Sometimes it's just not clear. And you just make your best effort to make the strongest argument. Other times, you know, it'll be clear that, no, I intend to remain here indefinitely. I own a home here, I'm just renting in Illinois. So that's not necessarily a cut and dry in this situation and in real life. But you, again, make the best argument you can. In terms of specific jurisdiction, the minimum contacts test, Driver was physically present in North Carolina when the accident occurred, utilizing state roads. He owns a home in North Carolina, and then he's getting some profit, so he's from that rent. He also receives an offer of employment there, and is applied to take the North Carolina bar. That applying to take the North Carolina bar allows you to make a strong argument that they intend to remain there indefinitely. His contacts are probably sufficient enough to satisfy minimum contact because he purposely availed himself to a lot of the benefits of the state of North Carolina, right? And then, of course, the same fairness factors listed to satisfy due process. And then a cause of action is the defendant's activities related to the cause of action. Absolutely yes. His presence in North Carolina at the time of the accident what gave rise to the personal injury claim. So yes, plaintiff will probably be able to sue driver in North Carolina, because that, again, the long arm statute applies, as well as the constitutional analysis. It would be fair for him to have to defend himself in the state of North Carolina. And then lastly, the B Corporation is in North Carolina, because their principal place of business is there, so we know for sure we have general jurisdiction. That's an easy one. So you don't even have to worry about satisfying the long arm statute because it's domiciled there. They're a resident. So remember, long arm statutes are for non-resident defendants. Corporation, when I say resident, domiciled, I'm using those synonymously, same thing. So if you're in corporation, if you're incorporated in a state or your principal place of business, you're considered a resident. You don't need to worry about the long arm statute. The long arm statute is what it sounds like. It's reaching over and trying to make a non-resident defendant come to that state and defend themselves. Okay? Yes?
Another question. For the analysis of B corporations in Georgia, I know that this student came to the conclusion that their contacts were not substantial to exercise general jurisdiction, but could you make a case that if they did enough sales there, that's where I'm just confused about where to
draw
it's
the
okay
line.
to make that argument,
Yeah, so, for exam purposes, you're gonna wanna make both arguments, right?
Okay.
But for practice purposes, it just depends on, what client you're serving. So, yes, you can make that argument, but you need obviously more details to know what percentage of sales, because I know you remember with the Daimler case, they were saying, even though it's a substantial amount of money, when you looked at the bigger scale in terms of, this billion-dollar corporation, it really wasn't a large amount of their sales as a whole to be considered at home. So, exam purposes, yeah, and that's outside of this class as well. You always want to show off what you know. That professors are looking for arguments, counter arguments, although I think this is a stronger one, could argue this, and then you draw a conclusion. That's what they're looking for. They want to feel like you're having a discussion with them while you're writing the exam. All right. Last but not least, I added that bonus to student did and transfer, just because we just covered it and I thought it'd be an interesting thing to consider. So, if the plaintiff does not decide to sue both defendants in Georgia, B Corporation can just try to dismiss the case for lack of personal jurisdiction. We'll talk about Rule 12 soon. Or transfer the case, right? We learned about our 1391 transfer options. Also, could transfer the case via Section 1404 to a more convenient forum, which would be North Carolina, which makes sense. The accident occurred there, so likely the witnesses are there, meaning in terms of injuries at the hospital, the car that was damaged and probably fixed or towed from North Carolina and so on. So I'm just added that bonus to the student's response to try to show you kind of how these pieces all fit together in the grand scheme of things. So my husband and I have this thing we do called Circle of Trust, right? That means we ask you to be honest, even if it's going to piss your partner off and you're not going to get mad at them. So I'm doing the Circle of Trust for you all. Did this thing freak you out?
Yes.
Or yes?
Yes.
Okay. What parts do you think would be helpful for me to cover again or emphasize? Yes.
I think I had trouble outlining what order to go in as you address everything.
Yeah.
So just, I think maybe not even seeing a sample essay, but just seeing just an outline format when you're presented with this question, you start here and then second, third, fourth, fifth, how to kind of go through it.
And addressing Ms. Clement's point, civil procedure is like one of the 2 classes in law school. It is very difficult to outline, and to be honest, there's not a right or wrong way. This is just an example. If you started with a specific jurisdiction analysis and then general, you can. It's just as a normal practice, people typically would do general first because then you can bring multiple claims, not just a claim that arises out of their action. Like I mentioned, McDonald's, you can sue them for anything. So you want general jurisdiction. So there's not really a right way. You're not gonna be discounted, points-wise. And because the bar exam is now multiple choice, I'm probably gonna give a few short answer to let you show off what you know, but 80% of the test will be multiple choice. But I need you to know the content, because if you see a little fact pattern, if you don't know the big picture where stuff fits in, you're not gonna get it right. If you know the material, you're gonna be like, oh yeah, there's no subject matter jurisdiction. I'll ask you, is there diversity jurisdiction here? You're gonna say no, because you're gonna see the amount in controversy. Either it's not over $75,000, or you're gonna recognize, ding ding, the plaintiff and defendant are domiciled and are citizens of the same state. But, so there's not really, and I think I've made a really strong effort to make this class as transparent as possible and not hide the ball. But this is unfortunately an area where there's really, you know, I'm not trying to be a jerk, but I can't show you how to outline it because there's not really a correct way. I just need you to see how the picture fits together. So you just need to know what each part means, and because on the, again, bar exam, which is what I really care about, they're gonna ask you, is there personal jurisdiction? Is there subject matter jurisdiction? Is there proper venue here? And you need to be able to say yes or no. So it's not really, sometimes it's helpful if students follow the table of contents that are in the book in terms of where you put stuff, but it doesn't really flow like you would want it to.
I had a question about the first prong of the long-arm statute.
Yes.
So you have to commit a tortious act, so I addressed in mine that technically we don't know who was at fault for the accident, so if one person was 100% at fault and the other not at all, then they did not.
Several liabilities.
Yeah, so they didn't commit any tortious acts, so the first prong wouldn't apply to them. So
Okay, so let me make sure I understand what you're saying. So you're saying that, oh, I didn't realize it's 10:16. I'll answer a question, I'll let you go. So you said because you didn't know who was liable?
Like I said, if the driver was 0% at fault, even though he went onto the sidewalk, if there's not any kind of strict liability or anything, if you're just talking about.
Yeah, you're totally overthinking that. All that matters is did the tort occur in that state, and was he involved in it? Yes. And
even if he wasn't at fault.
They'll do that at court. That's enough for them to satisfy, just to get him in court to decide. Yeah, don't over, that's amazing.
Do you have a part number?
So at the beginning of class tomorrow, after you have a chance, if you have more questions, I'm going to ask you.
But that wasn't what we were. Then I was like, then it's something I had a pig. Gotta go play party.
She's like literally saying on your outline, it's right here. Right there. You're fine.
Here, Dimitri.
Right.